Before we get into the next video, I would like to establish a few points for clarification. Our United technicians never knew of the December 9, 2010 CARP proposal from the company. Likewise, we are sure that the United technicians from Continental who have the CARP defined benefit plan never knew the Teamsters Union and their negotiators were working to terminate their CARP defined benefit pension in 2015. The Teamsters attorney, Ed Gleason, who wrote the grievance denial letter, rambled on for 20 pages, and he exposed the truth about the failed 8 years the Teamsters spent trying to gain control of our United 401k pension benefits. When we found out about the grievance denial, we began the process to fight for our right to have our grievances heard. In 2005, we drafted the pension language in LOA 0503M to give you a choice and an opportunity to vote on having either an increase in your 401k benefits or a defined pension benefit like CARP. The Teamsters Union denied you that choice and stole 6 years of CARP vesting benefits or an increase in 401k pension benefits from all of us. This is the problem with closed negotiations, especially when you have a dishonest union with hand-picked and appointed union negotiators and leaders. In case you United guys haven't noticed it yet, the Teamsters guys at United who denied you 6 years of CARP pension benefits and hold appointed positions as business agents and negotiators are basically the same guys who used to run the IAM and sold you the ESOP. Remember, the ESOP prevented us from contributing to our 401k plans, and it cost us all another 6 years of lost 401k benefits. Rich Petrosky and the Dirty Dozen, who brought the Teamsters Union to United, destroyed our contract language, reduced our medical benefits, reduced our seniority rights, and sent our work overseas. In total, the Dirty Dozen cost us 12 years of pension benefits. Is it any wonder we threw them out the first time? When your union resorts to lying to the membership to cover for their own failures, it's time for them to go. Secret negotiations with the Teamsters equals concessions. The Teamsters don't control the narrative anymore. They can't make excuses for their concessions. Just like their excuse to surrender our profit sharing and then rely on a non-union carrier and a convoluted formula for our future raises is a mistake. Hello, my name is Jim Seitz and I'd like to talk to you today about the Teamsters' denial of our grievance for CARP benefits for all United technicians. In the spring of 2017, the Teamsters drafted a 20-page denial of our grievance. They denied the grievance to cover for their greed and incompetence that resulted in the loss of 6 years of CARP benefits for all United technicians. Just like the failed cross-utilization letter the Teamsters signed after the merger, once again they showed their incompetence and inexperience when enforcing our contract. In this video, I'd like to expose the 4 false reasons for denying our grievance. The grievances that were filed are valid and they do have merit. We will show with facts and documentation that the Teamsters Union and its lawyers lied to the United membership about the case when they denied our grievance. Why would you want to be represented by a union that would lie to you and the entire United membership to make money for itself by denying our technicians their contractual rights to CARP benefits? Let's go over the reasons the lawyer, who was involved in contract negotiations, denied our grievance. We will show you that he attempted to deceive the United technicians about their rights to CARP benefits. First and foremost, this LOA was negotiated by United technicians in 2005. I and 10 other negotiators were at the table in open negotiations for all United technicians to observe. So when I state the reasons he is wrong on his statements, I am speaking from a point of first-hand knowledge. I, along with 10 other technician negotiators from every major station at UAL, were there. The Teamsters removed my name from the letter of agreement because they don't want you to know the original intent of this language. This is an act of deliberate concealment. Let's go over his phony reasons for denying the grievance their right to CARP benefits. Teamster lie number 1. The grievance is untimely by several years. The grievance is not untimely based on a provision in the LOA, paragraph 13, amendment waivers, which clearly states that failure to act in a timely manner shall not affect the rights to comply with the terms of this LOA. Specifically, the failure of any party at any time to require the performance of any provision of this letter of agreement shall not affect the right of that party at a later time to enforce the same or different provision. LOA 0503M Amendment Waiver. The company knew it had an obligation to the technicians and related by its initial offer to join CARP on December 9, 2010. The Teamsters denied this offer without our consent to place all United technicians into a pension plan that they controlled and profited from. Teamster lie number 2. LOA 17 obligations attach only to pre-merger United. The LOA and its obligations were in full force and effect and are carried forward just like any other contract provision under the Railway Labor Act. The contract is an agreement between the employer and the employees, as stated on the front of the contract book and on the front of this LOA. Additionally, the UAL Technicians Contract, Article 3 Status of Agreement, protects every provision of this contract. This significant article in our contract ensures that your contractual rights are protected during a merger. The Teamsters Union and their attorney are dead wrong on their position that the contract changes upon a merger of two carriers or the change in corporate name. They are seeking any straw man answer to avoid the responsibility in their own negligence towards United Mechanics and Related. In fact, they told the American and U.S. Airways technicians the complete opposite story in 2013 when they tried to raid U.S. Airways and American during their merger and negotiations in 2013. They are lying to you to cover for their mistakes and their failure to uphold their contractual responsibilities. Teamsters lie number 3. CARP does not trigger LOA 17's obligations because the CARP is not a single employer defined benefit plan. Nothing could be further from the truth. In their desperate attempt to find an excuse for their failure to offer CARP as required, they claim that CARP is not a single employer defined benefit plan, but a multi-employer defined benefit plan, which is not eligible as they claim per this LOA. They are wrong, and they have no idea of the intent of this language. The LOA was triggered by a merger of United and Continental Airlines. Continental's CARP pension plan and its obligations were assumed by United in 2010. The 2012 CARP Plan 5500 form shows that it is clearly listed as a single employer defined benefit plan. They can't even keep their lies straight. The Teamsters Union itself even describes CARP as a single employer defined benefit plan in its organizing campaign at U.S. Airways in 2013. Teamsters lie number 4. Even if its obligations otherwise attach to a post-merger, i.e. New United, LOA 17 does not specify when or how these obligations must be met. Again, the Teamsters and their attorney could not be more wrong. The effective date, which both parties are responsible for, is clearly outlined in the LOA when United begins to maintain the CARP-defined benefit plan. The LOA does not reference any time for negotiations or an implementation date, so all parties must go by what is clearly written in plain English. When United began to maintain the defined benefit plan, it had an obligation to provide those same benefits to the mechanics and related at United Airlines. Not 6 months from that date, not a year from that date, not after SOC, and not after a vote. United knew it had an obligation to its technicians and related, and it made an initial offer to join CARP on December 9, 2010. Unfortunately, the Teamsters never told the membership of that offer. The Teamsters Union caused the United technicians and related financial retirement damage by not presenting the 2010 company CARP proposal. The Teamsters concealed this guaranteed offer so they could place your 401k money into a pension plan that they controlled. Ultimately, their plan was to move all United technicians into this pension plan that they controlled. That means that they would terminate the Continental CARP plan in 2015 and move the remaining Continental technicians into a Teamsters-controlled pension plan. It is clear that the Teamsters are here to enrich and represent their best interest and not those of the United technicians. When they surrender our benefits, contract scope language, and seniority rights, while they increase our junior mechanics wage progression to 8 years and allow all of our wide-body aircraft work to be outsourced overseas to China, it is clear that they are not working our best interest. Again, why would anybody stay with a union that would lie and attempt to deny its members their contractual rights to a company-defined benefit pension plan? Take the time to share this video with your coworkers and get them to sign an ALTA authorization card. I would like to thank all the technicians who have helped us get cards signed and organized at our station. We appreciate the work you have done and continue to do to build a union like the Pilots Union for our United technicians.